and welcome. My name is Susan Beauvais with Welcome Home Realty International, and today I am excited to bring you important insights about the Florida as-is residential contract for sellers. If you're looking to sell your home in Florida, understanding the as-is contract is crucial. To help us navigate through the intricacies of this contract, we have a very special guest with us today, Jerry Rodriguez, with Rodriguez Albizu Law Firm in Stuart, a seasoned attorney with years of experience in real estate law who is bilingual as well. Thank you for joining us, Jerry. We really appreciate you sharing your expertise with us.
Thank you, Susan, so much for having us, for having me here with you today. And I'm excited to speak to you all, especially to you all sellers out there, about how the as-is residential contract works here in Florida. Now, a couple of things just before we get out of the gate, just to explain so all you viewers at home understand. There are two essentially types of residential contracts in Florida. We have the standard and we have the as-is. Both are excellent contracts to use. Both are done together in conjunction with the Florida Realtors Association and the Florida Bar. So there are attorneys who actually help put this contract together, which is why it's a great contract to use for residential purposes. The difference between the two is that under the standard contract, the seller can be obligated to make repairs to the home, depending upon buyer's inspection reports, up to certain repair limits during the inspection period. The trade-off for the seller is that the buyer cannot cancel that contract for any or no reason whatsoever during the inspection period. Under the as-is, which I would admit is the most commonly used that I see, 99.9% of the transactions I see that come across our desk is with the as-is contract. Now, why do sellers love that contract? Because they cannot be obligated to make any repairs at all during the transaction period. They're telling the buyer, hey, this is the house, take it with all faults included. This is what you're buying, and it's up to you, buyer, to determine if this house is suitable for your intended use. The trade-off for the seller in that instance, however, is that the buyer can cancel the contract for any or no reason whatsoever, so long as they're within the inspection period.
That's a good point.
Yeah. So depending upon what you want to do as a seller, one may be better than the other. And Susan here can certainly help you out figure out which contract's suitable or best for you all to use, depending upon your specific and unique transaction. Now, there's some other points that sellers really need to know about how the contract works. And the first and most important thing that I think sellers need to know is that when they sign the dotted line, no matter which contract they use, the standard or the as-is, they're in. They cannot cancel the contract just because they want to get out of the deal.
Okay.
So you need to be really certain that this is the offer that you want to take, and you want to be very certain that you want to sell your home. Because you don't have the ability to cancel the contract, unlike the buyer under certain circumstances, especially if you're using the as-is, right?
Okay.
So I think that that's a very important thing for sellers to know.
Very much so.
The next is that the deposit is very important for sellers. So under both contracts, the typical remedy that's afforded to the sellers in case the buyers breach the agreement is that the sellers get to retain the deposit as what we call liquidated damages. So that dollar amount that's listed as the deposit is really important for sellers to understand, hey, this is what you're going to get at the end of the day if the buyers don't close on your house or if they breach the contract. So you want to be especially sure that the deposit is commensurate with the purchase price of the house at issue.
Okay, so what would be a typical deposit amount that you would say on, say, a $500,000 house?
So on a $500,000 house, you know, I think an appropriate deposit is probably somewhere $25,000, somewhere along there. You want to make sure there's enough skin in the game for the buyer, right? That it hurts if they're going to try to cancel the contract. Because think about it this way, remember that even if the buyer is at fault and now you have a deposit dispute, how are you going to resolve that deposit dispute? And so even if the contract says you get the deposit, unless you have a court order saying you get the deposit, or the parties agree that you get the deposit, that deposit is not going to be released by the title company or the law firm handling the transaction. Most folks are not going to invest the monies it takes to hire an attorney to litigate, for example, over $5,000. The attorney is going to cost more than that. So you really have to think that it needs to be something that, as I like to say, gives the buyer a little bit of pain in the transaction, right? You want to make sure that it's real money on the table.
That they're serious.
That they're serious, exactly,
Yeah.
exactly.
Okay.
So that's a general idea as to deposit. I think it just depends upon the transaction, and you can do tiered deposits, which I think are a good way to go.
Okay.
So you do some money up front, maybe $10,000 at the beginning upon contract conception, And then after inspections are done, they got to lay another 15 on the table, right? So it gives the buyer it shows intentionality. It shows that they're serious about the deal.
Good faith.
Yeah, exactly. That's what we want to make sure of. The other thing that sellers, I think, need to take into consideration is that there are certain obligations, nonetheless, under the as-is, even though we call it the as-is, there are certain obligations the seller has to the buyer. Two important obligations can be found in sections 10b and 10j of the contract. Under section 10b, the seller represents by signing the contract that the seller knows of no improvements that were made to the property without the required permits or with permits that have not been closed out yet.
And what would some of those improvements be?
So the most common improvements that I see that do require permits in most jurisdictions, but for which, for whatever reason, rarely you see permits pulled, AC changeouts and water heater changeouts.
Okay.
So if you just changed out your AC or water heater, that's great, and it's a great selling point. But under the contract, your obligation is to disclose the fact in writing if no permits were pulled for that change out.
Okay.
Now, what's important to note there is all you have to do is disclose it in writing. You don't have to get the permit. You don't have to close out a permit. You just have to say, hey, I didn't get a permit when I changed out the AC. And your disclosure,
great point.
Yeah, and your disclosure obligation is done. So that's just something important to keep in mind. Right?
Okay.
The others under 10J, and under 10J, well, basically 10J says it represents Florida law on the topic, what we call Florida common law. But what it states is that the seller is not aware of any defects in the house which materially affect the value of the house and which are not readily observable through a visual inspection. So the common example I give, if the windows and doors creak when you open and close them, you don't have to disclose that, right? Because the buyer can do that themselves. They can open and close the doors and windows. They can hear that it creaks. They know that the windows and doors creak. But if you know, for example, that there's a leak in the roof, but there's no visual indication of a leak in the roof. For example, on the ceiling, you don't see any wet spots, but you know that it's a problem in your house, you gotta disclose that in writing. Again, all you have to do is disclose it in writing. You don't have to fix the problem. You don't have to hire anybody. All you have to say is, hey, look, we had a water leak, it hasn't been fixed, and the roof, just want to let you know. And the buyer then makes their decision as to whether they want to move forward or not.
Gotcha. Okay.
So those are two very important things that sellers need to know. What's the next? Under section 11, which is the as-is maintenance requirement. And the seller is required to maintain the property in the same condition it existed in as of the effective date of the contract.
And we see kickback on this sometimes.
Yes, you do. Yeah, exactly. So if you have a pool in your house and that pool is crystal blue clean, you got to keep it that way all the way through closing. You can't just fire the pool guy or the pool gal as soon as you sign the contract. Same thing with your hedges and your landscaping, right? So if you have beautifully trimmed hedges and nice landscaping, you just got to keep it up during the transaction period. If not, it can be an issue come closing.
And another thing that we've run into before is people not wanting to leave the utilities on.
Oh, that's a big problem, yeah. So the buyer does have a right shortly before closing, the day before or on the same day of closing, to do the walkthrough. And that walkthrough is critically important for the buyer because under the contract provides the buyer then through that walkthrough is confirming the seller complied with their obligation to maintain the property in the condition it existed in as of the effective date, and also to confirm that the seller met all other contractual obligations under the contract. So making sure your utilities are on so the buyer can turn the lights on, make sure the AC is running, for example. All those things are critically important that the buyer check out during their walkthrough prior to them proceeding to close on the transaction.
Another very, very good point. Thank you.
Yeah, absolutely. A couple other important points to keep in mind. Under section 8, you have your financing contingency. What's important here to understand is that not all loans are the same. And so the seller just needs to educate themselves on what is the difference between a conventional FHA and VA loan and how might that impact the transaction. The seller is also entitled, per the contract under section 8, to communicate with the buyer's lender to be sure that the buyer is doing everything they need to do to get their loan approval done. And the seller, most commonly through your listing agent, which is Susan, should be sending out those emails saying, hey, did the buyer apply for the financing on time? Has the appraisal been scheduled? Did the appraisal come back? Did it come back fine, sufficient for the loan that we're trying to get on the house? Were there any issues in underwriting that we need to know about or what have you. It's important that the seller maintain themselves informed of all those things as the transaction progresses.
Yes, there's a lot of things that we as real estate agents are doing behind the scenes after we get that contract accepted by all parties to make sure that you actually make it to closing.
Yeah, exactly. And these are all things too, by the way, that if you're represented by counsel in the transaction, which I always recommend, your attorney should be helping you figure out all these things too.
Good point.
Absolutely. What else are important things to keep in mind of the contract if you're a seller? Well, you also want to make sure that you have your listing agreement in order with your listing agent, and make sure everything's copacetic there so that there's no confusion at closing when that comes up. It's always important to ask the title company or the law firm that's handling the transaction, ask them for what we call a prelim, so that you get an idea as to what those costs are going to be when you come to the table at the end of the day. We don't want any surprises, right?
No,
It comes down to it.
That's never a good thing.
Exactly. The last and also very important thing I'd say that sellers really need to keep in mind is in Florida we have homestead laws. And so we see this come up every once in a while in transactions. So under Article 10, Section 4 of the Florida Constitution, we do have homestead rights. Now the homestead rights only come into play when we're talking about a primary residence and a legally married couple. So for all of you sellers out there, there's no such thing as common law marriage in the state of Florida. There's no such thing as being legally separated. You're either divorced or you're married. I don't care how long you all have been living apart or what have you.
Right.
That's what we look at. And if it's homestead property and you are legally married, doesn't matter who's on title, both spouses need to sign that deed at closing.
Great thing to keep in mind.
Yeah, absolutely. We want to do everything that we can at the beginning of the transaction and as that transaction progresses to make sure that we have a successful closing and that we close on time. And these are all things you got to keep track of throughout your transaction.
Amazing. Thank you so much for sharing this extremely valuable knowledge with us today. I think it's really going to be very helpful to a lot of the sellers that we're going to come in contact with.
Absolutely, Susan. It's a pleasure being here. Thank you so much for having me here to do this little talk with all of you all at home. Really look forward to seeing you at our office when you go to sell your house.
Absolutely. Once again, this is Jerry Rodriguez with Rodriguez Albizu Law Firm in Stuart, Florida, and I am Susan Beauvais with Welcome Home Realty International, where one happy neighbor at a time is more than our slogan. It's the words we live by.